Thank you for joining the Resilient Cyber Show. My name is Chris Hughes, and today I'm joined by Jim Dempsey. Jim, thanks for being here.
Chris, delighted.
Yeah, I'm excited to chat with you. I've been following your work, your talks, your lectures for quite a while now when it comes to cyber policy and regulation. But for folks who haven't come across you quite yet, do you mind telling us a bit about your background?
So I'm a lawyer, but I've been involved in policy issues related to technology for quite a few years. Practiced at a law firm, worked for 10 years on Capitol Hill, worked in the nonprofit sector as a privacy advocate, led a center at UC Berkeley Law School, where I still lecture. I teach a course on cybersecurity law, and I'm currently senior policy advisor at the Cyber Policy Center at Stanford University.
Yeah, excellent. Yeah, I couldn't think of a few folks better positioned to come chat today, given the timing of things with national cyber strategy. We're going to dive into that particular piece of publication here in a moment, but I wanted to ask. This is a question from my co-host who couldn't make it today. She said we're seeing a lot of efforts, within the regulation space around at the federal level, the state level, around regulatory and cybersecurity efforts. What are some of the trends, like broader trends, you think you're seeing across the federal and state ecosystem?
Well, we'll get into this later, Chris, when we get to the national strategy, but you're certainly seeing the federal government become more active with regulation of critical infrastructure. So for many, many years, the federal government took a bit of a hands-off approach, supported public-private partnerships, encouraged voluntary improvements by the private sector owners and operators of these critical infrastructure, energy, electricity, power, gas, transportation, communications. But now they're recognizing we need to go farther. They are starting to go farther. And secondly, I think I've been seeing over the past 4 or 5 years, a lot of activity at the state level. So what you end up with, unfortunately, is a crazy quilt, sort of a patchwork quilt. Some federal law, sector specific, some state law. You've also, obviously, in the data breach area, when you're talking personal information as opposed to operational technology, when you're talking personal information, lots of lawsuits, private litigation. So it's a very, very dynamic landscape, a very messy landscape in some ways. I think we're always going to have somewhat of a patchwork quilt. I think that's necessary. The different sectors are different. What's right for the banking sector isn't right for the nuclear power plants. But I think we're in this period of filling in the gaps, trying to understand what is the overarching framework. Is there a coherent vision, at least? If there's not a completed quilt, so to speak, does someone at least have a pattern in mind? And then how do we start filling in the pieces in some quasi-harmonized way? Because it'll drive people crazy. It'll just drive system operators crazy if there are always multiple rules for different applications of essentially the same technology.
Yeah, you actually kind of said a key word that I was going to bring up as you were talking there. You used the word harmonize, which we saw emphasized in the National Cyber Strategy, a need to harmonize, regulation and guidance and policy. And as you said, we kind of have this patchwork of compliance requirements for the state level, federal level, internationally.
Exactly.
What are some of the risks of not harmonizing? Because I know it can impose quite a bit of burden on industry, for example. So, what are some of the risks that we face if we don't harmonize well?
Well, 2 things. One is we don't get good results because we're not being systematic. So the tension here is the tension between tailoring, sector-specific tailoring, which again, at some level you need, the bank versus the nuclear power facility, versus harmonization. And if you're not aiming for harmonization, to my mind, it means that you don't really know why you're regulating and what you're demanding. Again, we have some relative commonalities across the technology that is being used. And What we need to figure out is, what is the vulnerability? What is the risk prioritization? What are the controls that should be put in place? And we need to do that on a technology-wide basis. Implementation, final risk analysis, ongoing monitoring is going to have to be sector by sector. But I think we have the cost and confusion factor, and people just saying this is just too complicated. I throw up my hands, or I'm just going to paper this over, or I'm going to do something superficial here. I'm going to check the boxes. That's one risk. The other risk, which I think of from almost an academic standpoint, but it's clearly has real world implications, is why are you imposing these particular requirements? And do you have a holistic view of threat prioritization, vulnerability prioritization?
Yeah, that makes sense. And you said something that made me think of my own experience. I come from the defense space, a lot of my background, and they kind of have a compliance checkbox culture, for better or worse, just because of how they handle cyber. So, I did want to dive into the national cyber strategy with you. Obviously, the timing of this has been great.
Yeah.
In that strategy, it talks about pushing the burden onto those, best positioned to do something about it. We've heard terms like least cost avoider in the economic sense, to the software producers and vendors, for example. And I know you penned an article recently where you talk about other parallels to other industries like automobile, for example. Right. Why do you think has taken us so long to get to this point, despite how pervasive technology is? And are we maybe we're moving pretty quick compared to how it's happened in other industries over time?
Yeah, well, why is it taking us so long? I mean, at some level, it's good and legitimate reasons. Around the 1980s, let's say, so 40 years ago, this new set of technologies began to emerge. The internet began to emerge. The interconnected world began to emerge. And some visionary people, including some visionary policymakers, some visionary lawmakers, saw that this technology had huge potential, that it could be a driver of economic development and innovation. And they were afraid that heavy-handed regulation would stifle that. And I think they were right. And I think at some level, the results prove them right in all of the benefits that we get from this technology and all of the ways it has completely pervaded every single sector: healthcare, transportation, everything, education, financial services, on and on and on. So I think don't regulate. Now, in a way, it wasn't really regulated. There was an underlying telecom regulation there that made it possible to interconnect all of our devices, and it forced the phone companies to carry the internet traffic, which actually the phone companies didn't want to carry initially. So there was a regulatory framework, but it was a regulatory framework based upon interconnection, interoperability, and allowing innovation at the edges. Okay. And we pushed innovation to the edges. We pushed functionality to the edges. And by and large, that was successful. Now, it had some negative impacts, which we're seeing. It's had negative impacts in terms of misinformation and disinformation and literal threats to democracy. And it has threats to the reliability and safety of these critical infrastructures: electricity, gas, transportation, healthcare, telecommunications, financial services, on and on, food supply, supply chain. Everything is now dependent upon interconnected devices, which are fundamentally vulnerable, right? We built this technology without a lot of security in mind. And this policy, this hands-off policy, which again worked in a way, has left us with these tremendously vulnerable critical infrastructures. And to jump to the cybersecurity strategy, which the administration issued last week, what this strategy says is, okay, we're now in a hole. We have some fundamental changes that have to be made. We have critical operations, critical infrastructures plus all of our personal data, sit on top of a fundamentally insecure network. And we've got to change the way we're doing business in how we approach that and how we think about that. I think that's correct. I think both choices were correct. I think the 1980s choice, 1990s choice was correct. And I think now the pivot to a focus on security is correct.
Yeah, I don't disagree with you there. I think that, that initial approach allowed the innovation and technological modernization to occur that we've seen, over the last couple decades, right? And now we've reached this critical mass, as you said, where now we need to start to try to get some governance and rigor around it. I wanted to ask you a follow-on question. I know we often draw parallels to other industries, from a regulatory perspective, like automobiles or manufacturing. And on the practitioner side, for me, we do the same thing when we talk about DevSecOps and software, software factories and things like that. But there's a little bit of a difference in terms of software. It's a bit more opaque. It's not tangible, like a steering column, for example. What challenges do you think that brings? It's not so visible and tangible like other industries.
Well, it is, and it is, and it isn't different, Chris. And let's explore that. And I'm glad you brought up the automobile analogy again. I didn't reference it when you respond to it when you first asked it. One of the things I've been trying to do as I think about cybersecurity is looking at how have we dealt with other fields and how have other technologies, how have other industries evolved, how have other societal problems been dealt with? Because I think there is a lot to learn. And it's fascinating in a way to go back and read stuff that people wrote about completely different sectors and to see the resonance. So automobiles, back at the beginning of the last century, early 1900s, of course, the automobile was beginning to revolutionize our society. And the automobile makers tried to disavow any liability for harm to the users, the consumers, the purchasers of the automobiles. And they had two theories. One is the Buick Motor Company, for example, said, well, we didn't, Mr. Consumer, the wheel on your car broke and the wheel was wooden at that time. This wooden wheel collapsed and splintered, but you didn't buy the car from us. You bought the car from the dealer. We never met you. We never saw you. In legal terms, that's called privity of contract. You had no privity of contract with us. So sue the dealer. And oh, by the way, even if you try to sue us, we didn't make the wheel. Somebody else made the wheel. And that stuck for about 10 or more years. The courts accepted those two theories. And then in 1916, a case came up before the appellate court at the state level in New York, and a Justice Benjamin Cardozo, who's now highly revered, his name is on law schools, went on to become a Supreme Court justice. He wrote an opinion saying, no, we've got to look at this from the perspective of who's in the best position to know what's going on here. And it's the automobile maker. They cannot just go out there, buy wheels over from this supplier, buy brakes from that supplier, buy the steering column from that supplier, buy the metal from that supplier, put them all together and take no responsibility for testing the components that they are including in the product. Well, doesn't that sound like the way that software is built now? You go pull something from here, which may be proprietary. You pull something from there, which may be open source. You put it all together, and this is what the strategy calls out, and you rush it to market because you got to get out there. You got to get out there and be first. You want to put it out there, and hey, yeah, things will happen, but we'll fix those later. Justice Cardozo said, no, you have a responsibility. You, the assembler, the person in the best position, because he said, what does the consumer really know? You can't really expect a consumer to look at the tire, and they can't even really get to the brakes that easily. And you can't expect the car dealer to inspect every car and to figure out how this was put together. Where is the party who has the responsibility? Now, Chris, we've shifted a little bit, and I think everybody needs to be aware. We've shifted from the question of what is the liability of the critical infrastructure operator, electric utility, pipeline, telecom company, versus the software developer, okay? And this strategy says we need to look at both of those sets of entities. The software developers, they don't really focus too much on hardware, they focus on software. And I think buggy software is the major problem. And then they look at the critical infrastructure operator. But using the automobile analogy, I argued in a piece last week, which I published on something called lawfareblog.com. Lawfareblog.com is where I put out a lot of my stuff to the general audience. And I argued that, the software industry is now where the automobile industry, about where the automobile industry was in 1916. And it is time to shift responsibility for buggy software, which up till now has been on the end user, of course, whether the end user is an enterprise, by the way, Chris, right? I mean, we're talking not only consumer users, we're also, in a way, even primarily talking enterprise users. So we want to shift the liability from the end user to the party best in position to understand what the product is and put some burden on them. Now, another fascinating thing about that Buick Motor Company case from 1916, the judge explicitly talked about risk, and he identified it specifically as a risk management problem. And he basically said, we're not expecting you to produce a perfect automobile. The standard is not perfection. But the greater the likely risk, up to and including in the automobile case, of course, loss of life, the greater the risk, the greater your responsibility to do the due diligence and to take on that duty of care. So just fascinating to take this 1916 case about automobiles with wooden wheels and think, what does that say about how we've let the software industry develop and where it sort of needs to go next? And it all comes down to risk management.
Yeah, it's too funny the parallels, like you talked about. Most modern software is composed of 60 to 80% of open source software components, they say. So it is kind of like you're more of an aggregator and someone putting something together versus necessarily creating everything from scratch.
And now you've got, AI assisted, autocomplete basically for software, and you've got all those libraries out there, and the possibility that not only is there just an unintentional flaw, but that the libraries have been poisoned. The dependencies have been forked somehow so that you're actually ingesting maliciously bad code. So, yeah, I think we saw with the Log4j, and even going back further than that with other open source incidents. But it's not to blame open source. I think we're always going to have open source. But it's in a way, what the administration is saying is that part of the burden is not on the open source developer. The burden is on the compiler, and not to use compiler in a technical sense, but the person who brings all those pieces together.
Yeah, I mean, I tend to agree with that. Is like, especially because an open source software producer or maintainer isn't necessarily even a supplier. They gave the software away as is. It's you who decide to use it, integrate it into a product. So you should be responsible for it. I wanted to ask you a question too. One thing that jumped out to me, and I'm sure everyone has noticed this, is that national cyber strategy had 5 different pillars. It talked about, securing federal civilian executive branch agency systems. It talks about national security and foreign adversaries. It talks about international collaboration. But one particular piece that really seemed to get the most attention is the piece around software liability.
Right.
Why do you think that topic in particular makes the industry just really, jump on that?
Well, people have called it the third rail of technology policy. You touch it and you die. It's the major software makers have used, going back to the old days, that so-called shrink wrap And now with software as a service, the browser app, the terms of service, they've used the terms of service to disavow liability or to limit their liability. And that's whether it's a purchase now, whether it's a purchased product or whether it's a service. And again, that was sort of essential to the development cycle and to the versioning approach and to the updating approach. Add new features, get the next version out there quickly. And again, I think the software industry can argue that that worked, that they were able to quickly innovate, they were able to quickly experiment, add new features, new functionality, new innovation, and they were able to do so rapidly. And that was the cornerstone of US policy, and I think global policy, but certainly US policy to software development for 40, 50, 60 years, whatever date you pick is the start of all of this. And what the administration is saying in the strategy, again, is this constant piling on of new features on top of otherwise buggy stuff, the need to constantly patch, the difficulties inherent in patching, particularly, again, in a large enterprise, let alone consumers. We have built a fundamentally insecure ecosystem. And so, and the power of the software makers, large and small, was very significant. They worked the Washington policy process. They relied upon these doctrines of contract law, which are ancient doctrines. They were able to draft these contracts, these terms of service, these licenses, whatever it was, in order to disavow or limit their liability. And now what the administration is doing is saying, okay, we got to move beyond that. Now, another reason why, leave aside for a minute the lobbying power of the large software makers, another reason why this has gone on so long is it's actually a hard issue. It's actually not going to be easy. People say, oh, well, Biden's not going to be able to pass anything to implement this policy. That's fundamentally misunderstanding the strategy. To say, oh, well, Biden's not going to be able to get Congress to pass anything this year, that fundamentally misunderstands where the strategy is coming from. This strategy is laying out a multi-year vision, and this is going to take years. The strategy says there are three pillars that we need to come up with here. One is we actually need to define the standard of care. We actually need to come up with some definition of what is secure software. Secondly, we need to figure out, probably by statute, how to overcome the current contractual disavowal of liability. We've done that in other fields, and that's why I say I want to look at landlord-tenant law. The landlord cannot disavow the implied warranty of habitability. Your lease cannot say, pay me $1,000 or $2,000 or $3,000 a month, but I'm not going to guarantee that the roof will work. Okay? The landlord can't do that. We've passed laws saying you cannot disavow the implied warranty of habitability of a home or apartment. But we've got to figure out how to overcome that now in the software field. And then the third piece, so define the standard of care, overcome the disavowal liability. And number three is then we need to have the counter to that, which is a safe harbor for those who do meet the standard of care. There has to be some assurance that they get that if they do everything right, they still won't be held liable. And this is one of the problems, Chris, with the current system, where it's all private litigation, it's all class action. You get a company like Equifax, had a massive breach, obviously. They've paid probably close to $1 billion between what they paid to the private litigants, the state regulators, and the federal regulators. they may actually have had a very good cybersecurity policy. They made one mistake on one web page with one implementation of the Apache Struts, again, open source app that they were using on one of their web pages. The bad guys found that one mistake and the bad guys exploited it. So the system we have now, and I think everybody out there who's involved in the industry needs to appreciate this. The system we have now is the tiniest mistake in the best program. If the bad guy finds the mistake, you face legal risk. And I think what the administration is saying is that's unfair. Yes, the bad guys are going to get through. Persistent attacker obviously is going to get through. What we need to do, though, is we need to look holistically at an enterprise-wide program and be able to assess it against some standard of care, which is going to be based on risk mitigation. It's going to be based upon a cost-benefit analysis. Now, defining that, we managed to define it for the automobile. We defined it for the toaster in my kitchen. Defining it for software. That's going to be hard. What the administration is doing, and I give them huge credit for this, is they're saying we've got to take this on. We can no longer ignore this problem.
Yeah, I think you're spot on. As many folks, you said a lot of great points there. One is that many folks are misunderstanding. This is kind of changing the dialogue that for years to come, not just a year. And also, I think that introduction of the safe harbor concept was critical to counterbalance, kind of the reaction to the software liability aspect of things.
Yep.
My next question to you was actually going to be about who defines what secure is and how we balance responsibility between supplier and consumer, which I think you touched on there.
Yeah.
So I wanted to ask you, a lot of people use the term market failure to describe cybersecurity. Yep. For folks not familiar with that term, what does it mean? And do you think that we do see a market failure basically with cybersecurity?
So our theory in a lot of areas is, the U.S., for that matter, Europe, but just stick with the U.S. for a second, as we have been. Fundamentally, a market-based economy, fundamentally a capitalist economy with many choices deferred to the market, to the producers and the consumers. And the theory of that is, it goes all the way back to Adam Smith and the invisible hand, that the consumers will demand good products and producers of bad products will go out of business. They won't be able to compete with those who develop the bigger, better, faster, safer, more secure product. And those market forces will ultimately even out, and we'll get that risk assessment will be made in that market interaction between consumer and supplier, producer. And that doesn't always work that way. And we've learned that over 200 years, 300 years of experimenting with a market-based economy. Again, going all the way back to Adam Smith and the Scottish Enlightenment of the 18th century. It doesn't always work. Now, why doesn't it work? Well, one reason it doesn't work is because you have information asymmetries, which is one party knows how the product works and the other doesn't. One party knows what's in the product and the other doesn't. The automobile dealer knows which are the lemons and which aren't the lemons, the used car dealer, and the purchaser has a very hard time telling what the prior, whether he's buying a lemon or not. Information asymmetry. So how do you cure? And then you have market failure due to monopoly power, which is a context that would occur, for example, in some of the utilities, electricity, water, etc. The sort of natural monopolies. You can have market failure because of what's called negative externalities, and pollution is the classic one. I'll produce a perfectly good product and the consumers love it. And it may be, in fact, a safe product, and it may be a cheap product and a fast and efficient and good product, but I'm pumping pollutants into the air. That's a negative externality. It doesn't directly affect the relationship between the purchaser and the buyer, and the consumer really has no way to influence the smoke coming out of the smokestack. That's a negative externality. And then there are things that we call public goods, which is we want some things that you really don't purchase. We want public safety that you can't purchase on the market or hard to purchase on the market. So at least four reasons for, and by the way, I'm indebted to Jay Healy of Columbia University for that framework. It's a very good framework. And so we have those market failures. And then what you have to do is you match the regulatory response to that. So a lot of our environmental control laws are about addressing the negative externalities of pollution. Things that aren't in the product, but are external to the product, but they hurt everybody, okay? So the car itself, or the plastic, you can understand the point there. Information asymmetries we address through disclosures, mandatory disclosures. The whole stock market is based upon disclosures. There was a huge market failure in the securities market, the stock market, in the 1930s, because some people knew the stocks were worthless, but the average buyer didn't, because there wasn't the information. So we developed a system based upon disclosure that every publicly traded company has to publish its financial standing so that the average investor can actually see, is the company as good as it looks, as it claims to be. Different approaches for each problem. And what we're now entering, so the strategy says flat out, we have a market failure. And it's really hard, Chris, for anybody to say, yeah, the market's working okay, because the market's clearly not working okay. Now the challenge is, okay, what are you going to do about it? And how can we match, and this is why this is a multi-year effort. It's not a one and done. It's not something that's going to be introduced in Congress next month. How do we match the problems and the causes for the market failure? And how do we use the regulatory system, the legal system, to compensate for information asymmetries, negative externalities, market power, public lack of attention to public good, et cetera?
Yeah, I think that's a great way to summarize what it is, and those aspects make sense. And I think we are seeing some headway in different areas, like on the asymmetry front, for example, we're seeing a push for software bill of materials.
Exactly.
Yeah, so I think that's a great example.
Exactly.
I wanted to ask you too, some of the pushback, I know we're almost down on time here. A couple of last questions for you is, one other pushback I see often from industry, and it has merit to it, in my opinion, to some extent, is, things like, say, in regulated industry for federal government, like FedRAMP, NIST 800-171, CMMC, that these things impose a burden on industry and essentially end up, leading to a smaller pool of suppliers that you get access to. Any concerns or thoughts on that topic, and how do we kind of balance that?
I think there are concerns there, Chris. I think that is a legitimate problem. One of the interesting things is I think you're not going to hear squeals from the big guys on some of this move towards regulation and liability. They feel, I think, that they can handle it. So yes, it is a burden. I think at core, this administration, and I think overall our system, is still a pro-innovation system. And it's certainly a pro-competition system. And I think there's acute awareness on both sides of the aisle in Congress and in the administration about monopoly power of big tech. So I think all I can say is that is a legitimate concern. I don't think it should stop us from moving forward, and it can't stop us from moving forward. I think we're going to need to look at how to support competition, to support the startup ecosystem, to support the small guy. By the way, not only, of course, we're not only talking about the tech startup. You referenced defense contracting. The guy who makes M16s or rifles or the next generation sidearm or the next generation rifle for the Army, they are subject to cybersecurity requirements as well in their own operation because they're receiving government information. So they're not even a IT company. They may be producing a tank or a Jeep or another kinetic physical product. They're subject to cybersecurity regulation. That's what the whole CMMC thing is all about, and the difficulties there. So yeah, it is an issue, but I think it has to be taken into account. That's about all I can say. It is a worry. The one flip side I would say is even the small guy does have to worry about cybersecurity. And you've seen the move to manage security service providers. I think don't roll your own. Small company, don't try to roll your own. Hire a competent third-party provider for your cybersecurity. But yeah, if you're in business with the government, you think you're not an IT company, you think you're a physical product or services company. No, you've got to pay attention to your IT, and you've got to button down the IT side, and you've got to figure out how to become compliant.
Yeah, I agree with you there. A lot of accurate points is, one is even if you're not an IT company, you're still using software and technology to manage FCI and CUI, for example.
Yep.
So everyone's kind of looped into that conversation. And I think, like you said, even though regulation may disproportionately affect smaller firms, we can't just ignore it altogether. So I think you're right there. It's just trying to find that balance. A second from last question. So I know you've talked about different compliance schemes, for example, and some use a self-attested model like the earlier, 80171 earlier versions of that. Others use a third-party assessment model like FedRAMP and CMMC. Each of those have drawbacks in the sense that self-attested models can lead to false or inaccurate reporting. Yep. There's revenue on the line, yep. But third-party attestations can also be cumbersome and time-consuming. With regard to the cyber strategy, which way do you think we'll see that go? Will companies self-attest? Will there be a third party involved?
I think it's going to be a mix, Chris. I think we're going to have both of those still as part of the framework. And I don't want to freak people out, but I think we are going to move, at least for the critical infrastructure. I'm specifically focused on critical infrastructure for this comment. For critical infrastructure, we are going to move increasingly to a government inspection model. The banks are already subject to this. The financial regulators, which inspect banks for financial stability, include cybersecurity in their annual reviews. These are done by government inspectors. They've been done, by the way, by government inspectors since 1864, when we set up the system of bank regulation during the Civil War in order to make sure that the banks weren't likely to collapse. So we are going to have all of those. Little preview, my next series, hopefully on lawfare, is going to be precisely on this question of enforcement. And I'm going to be looking at, it's hopefully a 3-part series actually, looking at issues around self-attestation, self-certification, and third party, so-called third party. And I put those quote marks around third party because there's some issues buried there. Who hires them? Who pays for them? Who are they really loyal to? Now, here's an interesting point, Chris, which I think is critical. There's a big difference between the self-assessment and or third party done as part of the development of an internal cybersecurity program. Absolutely critical. You cannot have a cybersecurity program unless you have self-assessed or hired a third party to do your assessment, right? And you need and can value from a third party coming in periodically to reassess, test, help you improve, okay? That's the baseline of any good cybersecurity program. What do we have? What is it doing? What's it connected to? What data is it processing? What are its vulnerabilities? And what are our compensating controls, okay? That's the self-assessment or third-party audit or assessment. But that's not really enforcement. Then the next question is, how good was that assessment? Are you actually doing what you promised to do? How effective are those controls? It's one thing to have a control. It's another thing to have an effective control. Those questions, I think, are the enforcement questions as opposed to the program design and review and revision questions. That's why I say self-assessment, third-party audit or third-party assessment is always going to be part of the cybersecurity framework. But in terms of responsibility, liability, and sort of assurance to the public, we are going to, for the critical infrastructures, telecoms, pipeline, electric utility, nuclear power plants, we already have it. Electric utilities have a complicated system already in place. We are going to move, ultimately, I think, have to move to some form of government inspection, as we have on other fields.
Yeah, I agree with you there. I think when you're talking about those critical systems, having that objective third-party, validation is crucial. So last question for you. First off, thanks so much for coming on. And
delighted.
You mentioned Lawfare blog. That's where I actually found you and started following your readings. It's been a year or two at least or more at this point. But, for folks looking to follow your content, I know you have a second edition of a book, for example. Where can they find you? Where can they learn more about what you're up to?
So I'm widely accessible, but I do use lawfareblog.com to post. I try not to write in an academic style. I try to write in a more accessible conversational style. Try to write shorter pieces. As you say, I've working on the update to the books. This came out in 2021, and so much has changed. I talk about criminal law here, and I have a webpage, Cybersecurity Law Fundamentals, all strung together, Cybersecurity Law Fundamentals, which is the title of the book, .com, where I post updates on the law. Sort of doesn't work. There we go. Perfect. It doesn't really work without the book, but to some extent it does. Check that out as well. You'll sort of see where my framework is. At least you'll get a sense of how I think about organizing this issue. And also on LinkedIn. Feel free to reach out to me on LinkedIn. I use LinkedIn to tell my network about my publication. So every time I post a piece on Lawfare, I put out a little thing on Lawfare. So happy to, all your listeners, Chris, happy to connect with them on LinkedIn.
Awesome. Well, thank you so much for joining us, and please keep up the great work. I'm a big fan of it, and I think a lot of other folks are as well. So thank you so much, and hope you have a good day.
Delighted. Take care.